Lord, one caveat to my answer to my Lord Hughes. Of course, it's possible if there's a 4-month detention of the vessel, that could result in physical damage to the vessel.
Okay.
If it did, then that would be covered.
Yep, thank you.
That also gives the
That's very thorough. It wasn't the question. It wasn't what I had in mind, but thank you.
It does point out that 1.2 is not simply focused on a CTL, even though that may be its primary focus. It can also, a capture of the vessel could result in damage to the vessel. Yeah. Similarly, a seizure. So
I should warn you, Mr. Abel and Mr. Schaff, that we remain concerned about the concession in respect of malicious acts. And I mean, it may not be necessary to decide it, but it's quite, on one view, we may end up deciding the case on an artificial hypothesis. And I think we're inclined at the moment to ask you both to put in written submissions. Having had a brief look at Mr. Justice Coleman's 2 decisions, they don't seem to deal with this situation because they deal with a situation where there was undoubtedly a malicious act either against an individual or against property. The footnote very helpfully goes on to refer to, amongst other decisions, Allen and Flood, and that may be of some relevance. I mean, personally, having had a look over the adjournment at the Shell Petroleum case, Mr. Justice Bustill treats the point as if it's pretty obvious that it wouldn't cover this sort of situation, and it was conceded by Sell in the Court of Appeal, and Lord Denning simply recites that. And to say that decided within 2 years, sensational as the case was, as I say, wasn't in the minds of the committee, seems to be quite a stretch. Whether maybe they knew all about Allen and Flood, but I think we would be helped, in fact. I mean, just in the interest of trying to get the law straight, even if we don't have to decide the point.
Well, Lord, if for that purpose we could be released from our concession to enable us to make...
Well, we're inviting it on both sides. Yes. We just think it's artificial to decide an important case on the construction of the policy, which will be taken in years to come without at least informing ourselves that the interpretation is correct when we have some doubts. I mean, I don't put it any further. I don't say it necessarily isn't correct, and you're both very experienced counsel and so on.
Well, as I said,
you didn't make it. I agree.
I didn't make it, so I wasn't involved. But I have to say that the minute my Lord mentioned the case, of course, I remembered that I have actually advised on the point, and so that case is something that's familiar to me. And but obviously,
well, it's very interesting to look back on it, and
yes.
I mean, it was a big case in my own chambers, as you can see from counsel involved.
Absolutely. But
I think generally as well. Right,
Lord. Turning back to the exclusions, the Lords can see that we had one proximate causation test in the insuring clause, and then for the purposes of the exclusions, we have another proximate causation test arising from. My Lords will note that none of the exclusions, save for 4.1.7, is limited in their application to any of the insuring clauses specifically, and the introductory words to clause 4 begin, "This insurance excludes," which is entirely consistent with the subject always language, and entirely inconsistent, save where the exclusions expressly so provide, for the exclusions to be cherry-picking insuring clauses. They are of general application. And that actually flows through when one does look at the detail of clause 4.1.5, because if one treats the word as one must, the words arising from as attaching to arrest, restraint, detainment, etc., we then have the further requirement that the relevant, I'll use detainment here, must be under quarantine regulations or by reason of infringement of customs or trading regulations. Now, as I said, if the proximate causation test is applying to detainment, then on my learned friend's analysis of the clause, we have then a third proximate causation test between the detainment and the quarantine regulations or the infringement of customs or trading regulations. Now, our submission is that when one looks at the language, it's plain that what this section of the exclusion is looking at is the reason for detainment. And perhaps the explanation for the difference in language under quarantine regulations by reason of infringement isn't as inadvertent as perhaps been suggested. The quarantine regulations, one doesn't infringe them. Either the quarantine regulations apply or they don't. If someone, let's say someone has some disease on the vessel and it's quarantined because the person is diseased, not because you've infringed anything, or may not necessarily be because you've infringed anything. It may depend on the local law. So to use the word under quarantine regulations is appropriate. One wouldn't suggest that the words under quarantine regulations are importing a notion of proximate causation. On the contrary, what they're doing is explaining the reason for the detention. And then one moves on to the next stage, and the words used by reason of are natural words of explanation of the reason for something. They mean for the reason that or because of. And yes, of course, those words in a different context may bear some different meaning, but in this context, their ordinary meaning fits in entirely with the text and context of this exclusion. It's explaining why the detainment has occurred. It's the reason for it, the reason the authorities have detained the vessel. And because it's an infringement, it's by reason of the infringement. It's because of the infringement it's been detained. So we have the two causation tests. Insuring clause, is there an insured peril? Does it arise from does the loss, in this case the CTL, arise from a detainment? Obviously yes, because otherwise there couldn't be a claim and the detainment wasn't inevitable. So it is a proximate cause. And then the next question is simply asking, well, when the authorities detained or the courts detained the vessel, was the reason for doing that infringement of customs regulations? And if it was, that's the end of it. What my learned friend tried to do is to try to pluck infringement out of its context of the explanatory nature of the reason for the detainment into some sort of freestanding requirement, which they say is satisfied by the malicious act, because the malicious act, they say, attaching drugs constitutes the infringement. But that's simply not a relevant question for the purposes of clause 4.1.5. It's already asked and answered the proximate causation test by asking whether the loss arises from a detainment. And if
I think there's a sort of possible risk of obfuscation through use of the word proximate cause, which is
yes.
sometimes been substituted by effective cause or real cause. I mean, there's no particular reason why you shouldn't have a first stage question: what is the cause of this loss? It's the detainment. And then a second stage question: what caused the detainment? Infringement of customs on trading regulations. So
Yes.
you could say that there is a proximate cause of the event, which was the proximate cause of the loss. You could, if you wanted to use that terminology, it may be just simpler to say what's the real cause or the effective cause at each stage, or alternatively use your terminology, which is, I think, to distinguish between proximate cause as the confined to the actual cause, immediate cause of the loss, and then say, well, what is the explanation for that at the second stage?
One can use proximate cause loosely to cover this third stage.
Yes.
But what the authorities demonstrate is you're looking for the reason for the authorities acting. It may be a good reason or a bad reason in the sense that it's genuine, but the court wouldn't have agreed with their construction of their local legislation, but that doesn't matter. As long as it wasn't for some ulterior purpose, as long as the real reason wasn't some political motive to seize the vessel, if that was in fact the reason for continuing to detain the goods, what caused that decision to be made in terms of extraneous factors is utterly irrelevant. It's only if one seeks to drag in through some proximate cause test other factors that the use of the word proximate cause leads into error. And that's where we submit that the owner's case falls into error, because they say by reason of introduces a proximate cause test. So now you can open up the agenda to all these potential causes and look for which is the proximate cause, whereas the clause is actually focusing on why the authorities acted as they did. Regardless of how they came to be acting as they did, regardless of what triggered it, it's simply asking, did the authorities detain this vessel because there was an infringement of customs regulation? Of course, even if one does apply a pure proximate causation test and open up the agenda to all other factors as well, we still say that at least a proximate cause was the infringement of customs regulations, because that was the only legal justification. But actually, Learned Friend's argument about the impact of the malicious act can only really come in to the second stage, which is whether the loss was proximately caused by a detainment. Or was the malicious act the dominant cause? And we say, well, it can't be the dominant cause in circumstances where it simply could not have caused the loss without more fortuitous events occurring, which resulted not only in a detainment, but a detainment for 6 months. And those fortuitous events were all to do with third-party interventions, the second inspection and the discovery of the drugs and the decisions of the courts. As we've conceded, that doesn't extinguish the causative effect of the malicious acts, but it means that they had to share their causative potency with something else. And in essence, the structure of the exclusions and the insuring clauses inherently contemplates concurrent causation. These exclusions are not simply the reverse of the insuring clauses that one sometimes finds, where exclusions are merely confirmatory of the ambit of the insuring clauses. These are biting on the insuring clauses as recognised by the draftsman with the words subject always to and this insurance excludes.
I wondered whether one could test that by comparing clause 1.1, which covers war, etc., or any hostile act by a belligerent power.
Yes.
Right. So if you had a confiscation by a belligerent power or a seizure, and then the underwriters said, but the belligerent power was the country where your vessel was registered, and looked at 4.1.4.
Yes.
Capture seizure is excluded if it's by or under order of the government of the country in which the vessel is owned or registered. So there's an example of the capture seizure provision, if underwriters would be right on that point, which applies to something other than 1.2 or 1.6.
Yes, not exactly.
Belligerent powers frequently captures, seize ships, or confiscate them.
And if it's bad luck for you that it happens to be where your ship is owned or registered, well, that's tough. It's excluded.
Well,
And it may be
actually
that
concerned with requisitioning, isn't it? I mean, there's a string of cases about
Spanish Civil War.
ships being placed under Admiralty orders or nationalised during the Spanish Civil War and so on.
But it doesn't matter whether the application of 414 is not something which was within the core of what was being anticipated. If that's fortuitously what happens, that is, the exclusion applies, and no reason why it shouldn't. And we say that once one analyses 4.1.5 in that way, that what it's looking for is, as long as the detainment is a proximate cause of the loss, if it is a qualifying detainment, in that the reason for it was an infringement of customs regulations, it is excluded, that is then consistent with the approach that all the authorities have taken to this clause, which is to say that this part of it, the customs infringement, is aimed at excluding smuggling. And it's not simply barratrous smuggling, it's smuggling. It doesn't say customs infringement for which the crew is responsible. In fact, there is an unappealed decision of Mr. Justice Hamblin, which explicitly holds that 4.1.5 does not require owners to prove any complicity of the owners or the crew.
Say unappealed, that's not appealed.
That's not appealed, no.
Which case is that?
That's Mr. Justice Hamlin's decision.
In this case?
In this case, yes. One of the issues he was asked to decide was whether 4.1.5 does require proof by the owners of does require complicity by the owners or the crew, whether the insurers had to prove that. Of course, the crew were convicted. 2 members of the crew were convicted in this case, but it was not tenable for insurers to seek to uphold their guilt at the trial of this action. But Mr. Justice Hamblin rejected any such restriction on it And that's quite right, because if one views this as explaining the reason for the detainment, then as we submit that all ties in with an analysis of what this exclusion is seeking to do, which is to take smuggling out of the war risk by whomsoever, which is why you don't have to prove who it is that's guilty of it. And of course, there's sense in that, because as a matter of practical reality, it will always be near on impossible for insurers to prove who was actually responsible for the smuggling. May be rather easier for the owner to prove who was responsible for it or who wasn't. The proof may not be satisfactory, but it may often be difficult for insurers to challenge. But as far as insurers are concerned, again, I reiterate, one looks through 1.1 to 1.6 to see the nature of the risks. Whatever decision my lords reach about, or if you reach a decision about the ambit of malicious, what is clear is that, as I've already submitted, that the primary focus of malicious, at the very least, is not on something like smuggling. So there's no reason why insurers shouldn't be drawing within the all-encompassing nature of the exclusion for smuggling by third parties, in circumstances where they're well aware of the practical reality that one can never really prove who did it, who was responsible, or whether the crew were or weren't complicit.
Well, that's a common enough problem in marine insurance when you've got express allegations of barratry or of casting the ship away. You always have to answer exactly that sort of question.
Yes, but in this case, we've got a situation where there are decisions of the courts that precede the introduction of these clauses, the repetition of these clauses that describe this exclusion as being aimed at smuggling. It was adopted again in 1983 on the basis that that's how the courts had viewed it, as aimed at smuggling.
Aimed at smuggling, what are the decisions you want?
Well, Lord, I'm going to come to the cases
Right.
in a moment. Can I deal with those in a moment? Can I just, though, conclude that it's the Anita, but also Corey and Burr has significance in this as well. But can I just conclude this aspect of my submission with identifying what we say are the fundamental flaws in the owner's case on the construction of 4.1.5. Firstly, they seek to read into the clause an implied limitation where not only is there no necessity for an implied limitation, but there's no good reason for it either. And it would be fundamentally inconsistent with the subject always and this insurance excludes language. Secondly, they seek to exclude from consideration the causation question in relation to the initial detainment and the continued 6-month detainment by focusing on whether the malicious act of attaching the drugs to the hull caused the infringement, when that is simply not a relevant question under the clause. It detaches the word infringement from the words which precede it and its context. Thirdly, they seek, either by reading additional words into the clause or by ignoring words that are there, to achieve a result that not only is there no indication that the draftsman intended to achieve, but is actually contrary to the result the words used indicate that the draftsman was trying to achieve. So they try to say that this doesn't apply to cases where a proximate cause is 1.5 malicious persons, in circumstances where the language indicates it was intended to be all-encompassing. Fourthly, they seek to justify their approach by reference to what we submit are far-fetched and outlandish hypothetical scenarios, which firstly cannot ever be a sound guide to construction, and secondly, distract attention away from the real goal of this clause for common situations like the present case, and which, in any event, can all be rationalised against the clause in the way that we have explained it. We have the put-up jobs. The government puts drugs on the vessel for the purposes of then discovering them and detaining the vessel. Probably isn't an infringement of customs regulations at all, because the government's done it itself. But in any event, one could answer the question on a proximate causation, on the either a proximate causation test that the detainment by reason of customs regulations was simply the inevitable result of the government's stratagem and not an additional fortuity, or one can say, well, their detainment, the real reason for the detainment of the vessel wasn't actually any infringement of customs regulations. That was just a pretext. The real reason was they wanted to get their hands on the vessel. So there are all those ways of explaining it. If it could be proved that the drug dealers deliberately tipped off the government as part of their stratagem, they plant the drugs and tip off the government because they want to offer one consignment to the government, then it may be said that the government's detainment of the vessel wasn't fortuitous. It was inevitable and planned, and so the original malicious act, if covered, was and remained the sole dominant cause. A tip-off by a member of the public, well, we would say that was still fortuitous, because that was the fortuity which led to detection. You needed something else for the loss to occur. It's just a different fortuity from the divers discovering it themselves. One way or another, one doesn't need to manipulate this clause for these extreme and extraordinary examples. One can find the answer in the clause itself, but even if one couldn't, the answer would be, well, one simply shrugs one's shoulders and says that sometimes clauses don't address extreme and unforeseen instances. It's not a recipe, a basis for rewriting the clause. My Lord, fifthly, and perhaps most importantly, if the learned friends are right, it does leave 4.1.5 with hardly anything to do. It really emasculates it, because barratry is already out, as learned friend accepts, even if there is a want of due diligence by the owners, because he accepted that barratry by the crew would not fall within the ambit of malicious acts. But of course there is also exclusion 4.2. So that's already outside the clause. So what's left? Well, I suppose it could be an innocent act by a third party, inadvertently bringing something onto the vessel, putting something on the vessel which put it in breach of customs regulations. But if that's right, what chance is there of that leading to a 12 months detainment? In circumstances where the evidence in this case was that in 99%, of course that percentage may be an exaggeration because not so many vessels were actually detected, but in other cases, the vessel had been released within a matter of a month or so, where there was drugs attached to the hull of the vessel. So if one would expect ordinarily the vessel to be released quite quickly, then what possible reason would there be for the draftsman going to all the trouble of having this exclusion for innocent breaches of customs infringement which were inherently unlikely to lead to a CTL at all? So commercial purpose, giving commercial purpose to this exclusion necessarily requires a construction which is contrary to the owner's case. Finally, on construction, there is the point about issue 3 of Mr. Justice Hamlin, and whether one can say that 4.1.5 only applies to 1.2 and 1.6. In fairness to my learned friend, he hasn't been able to advance, hasn't really sought to advance a coherent argument on construction to support this, which is hardly surprising in the light of the subject always, and this insurance excludes language. But it also fails, we submit, for a more fundamental reason, and that is that in order to succeed in this case, as I've already explained, owners have to rely on a detainment for the purposes of Clause 3. That gives them their constructive total loss. So if one was to look at this case and ask which insuring clauses cover this loss, one would say 1.2, and on the hypothesis that of the meaning of malicious, 1.5. What we know on the basis of this submission is that insofar as insuring clause 1.2 applies, which it does, the loss is excluded. The fact that the loss also qualifies under another insuring clause cannot, in our submission, operate as a gateway to cover, because the result would be that insurers would be having to provide an indemnity for a loss which they'd excluded.
Well, that slightly begs the question as to whether the exclusion applies to 1.5. It's perfectly possible, isn't it, to have an exclusion to have two, I suppose it's perfectly possible in theory to have two insuring clauses, one of which is subject to exclusion, which applies, but the other of which continues to offer cover, because the exclusion doesn't embrace it.
But the difficulty with that, of course, is that in order for 1.5 to get to the loss, it has to go via detainment, which is 1.2.
That's the more, yes, I see that point.
Yes, that's the problem.
Yeah.
And then you're saying that actually it works, my Lord's argument works, if one can say that 1.5 is the sole dominant proximate cause.
But since it's got to go one through clause 3, how can it escape
Yes.
4.1.5 when clause 3 and 4.1.5 are in pari materia, really?
Yes. But in any event, if you get into the Wayne Tank point, that if it qualifies under 2 insuring clauses, let's put aside 1.3 for the moment, clause 3 for the moment, let's just focus on 1.2. It is proximate, the loss is proximately caused both by a detainment, qualifying under 1.2, which it has to in order to get through clause 3, and it qualifies under 1.5. It has 2 proximate causes, one of which is excluded from cover, and one of which is covered.
Yes, but the difficulty, I mean, Wayne Tank is not analogous, is it? Because in Wayne Tank, both causes were necessary. You had to combine the two. You had to have a negligent operation on top of a negligent fitting of the tape.
I think, in fact, you didn't there. They're holding, yes, you did, but one was the dominant cause on the facts.
Yes, but
the hypothesis was if you had
yeah,
to.
Whereas here, they say we're not having to combine the 2 clauses, 1.2 and 1.5. On the contrary, they say they're independent and self-standing, and if you knock out one, doesn't mean say the other doesn't stand.
But the answer is you have to combine the 2.
But you say for clause 3 purposes you have to combine the 2. I can see that.
Well, and also, it's not just clause 3. It's if you're asking what was the proximate cause of the loss, it required a combination of the 2 causes for a loss to occur. It required a detainment under 1.2, as well as the malicious act. Planting the drugs on the vessel would have caused no loss at all.
Yeah, no, I do see. Yeah.
And so that's why I say, although, yes, it's a clause 3 case, it actually triggers 1.2, and it has to, for them to succeed.
That's the point I was making.
Yes, I thought that's how I understood it, but that's and so it simply doesn't work. And if it doesn't make sense, then one does then come to the conclusion that it can't be the correct construction. Lord, I apologise, that was laborious, but close analysis of the language of the clauses actually does, in our submission, provide the answer as to how it all fits together and works. And then one goes to the authorities and one finds that actually this approach to construction is entirely supported by what is said in the authorities, and the approach to causation is as well, and they in turn also provide the legal context, insofar as they predate the 83 clauses, to what those clauses say. And my Lord, I just want to deal with the important cases in the field. With Corey and Burr is the one I want to start with, and that's at tab 1 of the core authorities bundle. And what is the first point of significance about this case is that exactly the same implied limitation argument as is run by the owners was run in that case. And one can see that at page 406. Just as a reminder, the policy covered barratry, and it had the free from capture or seizure clause. And my lords will see on page 406, in the course of the summary of argument for the appellants, about 2/3, 3/4 of the way down, just below the references to Hayman and Parrish, Livy and Jansen, and Hahn and Corbett.
Just after 10.
Yes, just after 10, my lord, yes. The word, the warranty may be read free from capture or seizure unless caused by barratry. So what they were saying was, well, this policy expressly covers barratry, and so this free from capture or seizure clause should be read as subject to the insuring clause. And that was given relatively short shrift by the court. Earl of Selborne, the Lord Chancellor, at 409, at the top of the page, says, but then it is contended that although there was a capture or seizure, and though the capture or seizure only caused the loss, then there would have been no loss without the capture or seizure, yet if a claim might be made upon the footing of barratry, then the warranty does not apply. I confess I've never seen how such a construction could be put upon the policy and the warranty taken together without leading to consequences altogether destructive of the whole operation of the warranty. And then further down the page, unfortunately these don't have the letters on the side, but about 2/3 of the way down, it is quite manifest. It is quite manifest that the object of this warranty is and must be to accept such losses otherwise covered by the policy, otherwise coming within the express terms of the policy, as arise out of and are losses occasioned by capture or seizure. That appears to me equally the case whether remotely it was occasioned by barratry or not. In fact, the remoter it is, the stronger the argument that it must be the case, as to barratry. So he's rejected that argument. Lord Blackburn also rejected it at page 414. At the top of the page, the question is then reduced, it seems to me, to this: when the whole loss was occasioned by that which was certainly a seizure, is it within the meaning of the warranty? I say certainly it is. And at the very foot of the page, 4 lines up, all that is necessary in the present case is that the warranty is against a seizure by a power. And finally, Lord Fitzgerald at page 416. The last paragraph on the page, the contention of the plaintiffs is that the warranty does not apply, whereas in this case before us, the seizure has been the immediate consequence of the barratrous act of the master. And on the other hand, the defendant insists on the literal construction of the warranties embracing all cases in which the ship has been taken forcible possession of by superior power or authority. And then he continues on the next page, the top. The question seems a simple one, but if we depart from the literal construction, we may lead into complications and metaphysical refinements from which mercantile contracts ought, so far as practicable, to be free. And then in the next paragraph, about 5 or 6 lines down, it says the literal interpretation of the exemption would embrace all cases of capture or seizure which would otherwise have been within the perils insured against, and so far as the authorities have gone, they are in favour of the defendant's contention. So explicitly rejecting the contention that a seizure capture exclusion somehow must be read as subject to an express grant of cover for barratry. The second point about, that's the first point about Corium Burr. The second point about Corium Burr is that the result in that case is fundamentally inconsistent with the owner's case. The covered peril was barratry. The exclusion was for capture and seizure. The barratry created a situation in which the vessel was liable to capture or seizure if the attempted smuggling was detected. It was fortuitously detected while the vessel was hovering off the coast waiting for the goods to be collected. Unfortunately for them, a customs vessel turned up, and that seizure triggered the exclusion and overrode the cover for barratry. It's exactly analogous with this case, assuming there is cover for malicious acts. Third point, is that it's not distinguishable by reference to the fact that the form of words used was free from capture or seizure. At page 412 in the authority, in the electronic bundle, Lord Blackburn identified two types of warranty and identified this type as being equivalent to an exclusion. He said, now comes the question, does this warranty free the underwriters from that responsibility? That is the main question. First, let us see what the warranty is. There are warranties such as those which were referred to in the ingenious argument that we've last heard, which in effect merely say, we will define the sort of adventure which you shall engage in when we are to indemnify you. And he gives examples of that. And then about 6 lines down, he says that is one description of warranty. But there is another which has been for a long time used, expressed in the phrase warranted free from particular things. And then about 2/3 of the way down the page, he says that kind of warranty, warranted free in that sense, means that although the general terms of the policy would have covered this, yet considering the special riskiness of the particular matter, the underwriters, unless they're paid a premium for consenting to take it in, do not choose to be liable where the particular thing happens, which they've stipulated by this warranty, that they shall be warranted free from. Now here they're warranted free from capture and seizure and the consequences of any attempts thereat, and then the passage that I've already read. So he's treating warranted free from as simply being equivalent to an exclusion, and he's right to do so. That was endorsed in Wayne Tank, which was a non-marine case, of course, tab 9, page 531. You have the benefit of the side lettering now. Letter G.
541, did you say?
531, my lord. Right. I may have misspoken. Letter G. Mr. Lacane sought to avoid the impact of the judgment by submitting that warranted free in a marine policy had a different effect from an exception in a non-marine policy, but it seems to me it has no different effect. It's simply a different mode of expression. And of course, he was dealing with a standard non-marine exclusion in that case. When I say standard, I mean typical rather than a standard form. I'm not suggesting it was a standard. 533, letter D, Lord Justice Cairns. Letter D, he says, I do not consider the distinction which Mr. Lacane sought to draw between warranted free and an exception is a valid one. And at 539, letter A, Lord Justice Roskill, perhaps a little bit more expansively, Mr. Lacane argued that this was because the words warranted free in a marine policy which do not appear in the present policy, and suggested that a different rule applies to a non-marine policy such as the present policy under consideration. But in Sir Mackenzie Chalmers' book on the Marine Insurance Act, the editor says, this passage goes back to the author's editions, in relation to the words warranted free from, take the case of the warranty free from capture and seizure. This sure does not undertake that the ship or cargo shall not be captured. That is merely a stipulation that the policy shall not apply to such a loss. And then Lord Justice Roskill continues, an exception clause is inserted into a policy of insurance, whether marine or not marine, in order to exclude liability which, apart from the exception clause, would rest upon the underwriter. I cannot think that the effect of the exception clause depends on whether it's preceded by the traditional words, one might also say traditional jargon, in a marine insurance policy, warranted free of, or the less romantic and more mundane words of a non-marine policy, the company will not indemnify. I think the law in this respect is the same both for marine and non-marine. So we're dealing here with, in Corian Burr, simply an exclusion. An exclusion versus cover for barratry. And the exclusion is not read as subject to the insuring clause.
Is the next sentence that he speaks relevant as well?
Yes, my lord, that's on a separate point.
It is on separate.
Yes, it's on, and that's the two causes operating at the same time. But the purpose of all this was the attempt by Mr. Lacane to distinguish the two causes in the marine field by saying warranted free from is something different from a non-marine exclusion.
No, but if you had a 1.2 and a 1.5 cause, two causes operating simultaneously, if that were the analysis, that sentence would be relevant.
Yes. And I'll come on to that aspect of Corey and Burr as well. If anything here, our submission, of course, is that the language is stronger because of subject always, and this insurance excludes. In fact, to have equivalent linguistic force to the present policy, the warranty in Corey and Burr might have said warranted free from any capture or seizure. But free from capture or seizure was sufficient on its own. The next point is the point my lord was adverting to, the causation analysis. And that finds its way through to Wayne Tank, and my lord can see the reference to Corey and Burr on the page we still have open at just the page before at 538. Corey and Burr is cited on the previous page between letter F and G, and that was the attempt to distinguish it because of the warranted free from language. But we have Lord Blackburn's analysis, which is now accepted in the authorities and by the owners as the correct legal approach, that one can identify two proximate causes. In that case, he specifically identified on the facts of the case barratry as a proximate cause and the fortuitous detection of the drugs by the vessel, the naval customs vessel that apprehended the smuggler. So there were the two combined causes, and the facts are, for all intents and purposes, indistinguishable from ours. You have smuggling, which would have caused no loss, but in fact causes a loss because of the detection. And my lords want to see the facts. That is at 412. At the foot of the page, but I think I said I'd read this passage, but I hadn't. It was argued here, Lord Blackburn says, about 4 or 5 lines up, that they have not been warranted free from barratry. That is true, but the barratry would itself occasion no loss at all to the parties insured. If it had not been that the Spanish revenue officers doing their duty, they were quite right in that respect, had come and seized the ship, the barratry captain, in coasting along there, hovering as we should call it, along the coast in order that the small smuggling vessel might come and take the tobacco, would have done the assured no harm at all. The owners do undertake to indemnify against barratry. They do undertake to indemnify against any loss which is directly sustained in consequence of the barratry. And in this case, as I said before, I think the seizure was as direct a consequence of the barratry as could be. But still, as Mr. Justice Field says, it was the seizure which brought the loss into existence. It was a case of seizure, then why should it not be protected by the warranty? And that's his effect. I mean, that's why we say, yes, the act of attaching the drugs to the hull was a proximate cause, but so was the fortuitous detection of them and subsequent detainment. And my lords, we say that the approach in Corianburgh, a decision of the House of Lords, is directly applicable to this case and therefore requires to be followed by this court. Lord, moving swiftly on, I hope, to the Anita. This is Mr. Justice McCatter at tab 2 and the Court of Appeal, tab 5, I'm sorry, my lord, tab 5, and Court of Appeal at tab 6. The added significance of this case is that it concerned the 1959 version of this exclusion, as my lords can see from page 491 at letters F to G. And if my lords go up to D to E, you can see that the policy covered barratry. The facts are at 489 to 490, and my learned friend has summarised them, but this is at H, vessel arrived at anchorage 40 miles downriver from Saigon. Customs authorities inspected her, found concealed in the ship a large quantity of transistor radio sets, watches, batteries, cigarettes, and flasks of liniment, so-called, all things useful to fighting men. Goods were hidden in a cavity behind the rudder of the ship. Opening to the cavity was closed by wooden planks, over which there was a layer of cement and iron bolts. Deliberate concealment of materials of war. Taken up river 40 miles, Saigon, searched again, this time inside another hiding place closed by wooden planks. Customs authorities found many more radio transistor sets. And at 491 B to C, at B really, they found 5 of the seamen guilty and sentenced each to several years' imprisonment, fined 4 of the seamen sums of money which they settled by payment. The court ordered the confiscation of the vessel, confiscation of the seized goods. In addition, the court made an order which is important for the present purposes. They ordered confiscation of the SS Anita, which was used as a means of transport. Just as an observation, counsel in the case, my lords can see at page 489, letter E, including Mr. Mustle, Mr. Staunton, and Mr. Gilman for the insurers, and Mr. Goff, Mr. Eckersley, Mr. Kinnell for the owners. Quite formidable teams. The first point to note about this case, my lords, is that despite the eminence and experience of counsel and the expertise of solicitors who were, in fact, Ince & Co. and Hill Dickinson, well-known marine solicitors, no one saw fit to suggest that the exclusion should be subject to any limit or qualification in its operation by virtue of the fact that the infringement of customs regulations was attributable to the barratry of the crew. It wasn't submitted, it was the infringement was the mere manifestation of their barratry. It was just as much a so-called mere manifestation of the crew's barratry as this is said to be a mere manifestation of the malicious acts. If the owners are right on this appeal, it would seem to follow that the owners ought to have succeeded and that they and the courts, who included in this case Sir Gordon Wilmer, a former Admiralty judge, everyone overlooked this winning point. And there is no real basis for distinguishing this situation. The fact that we're now looking at an insuring clause addressing malicious acts rather than one for barratry makes no difference to the relationship between insuring clauses and this particular exclusion. It either applies regardless of whether something is within an insuring clause or it doesn't. The nature of the insuring clause can't affect that analysis. There is only one possible distinction between this case and the current case, and that is that the vessel moved. Because the vessel in Anita had moved after the crew had stashed the contraband, whereas, of course, this vessel didn't move. Lords, if the application of this exclusion was to turn on whether or not the vessel moved, it would be perhaps one of the more ridiculous exceptions known to mankind. Either it applies or it doesn't, and it can't depend on the moment of the discovery, whether it's before or after the vessel happened to have moved at all. The second point about the Anita is it confirms what this exclusion is aimed at. One sees that, my learned friend has referred to these submissions, but just so my lords can see them. Tab 5, Mr. Mustill at page 470. In the left-hand column, about halfway down, have his lordship saying the fact that the government has decided to take more stringent action does not matter. Mr. Mustill, it does not. All you have to be satisfied about is that this is in the realm of customs. And on the right-hand column, about 3/4 of the way down, or just over 3/4, Mr. Mustill says the risk of seizure is not the risk of barratry. Barratry did not have the feel of a war risk. There was no need to go into the minutiae of Vietnamese law. The underwriter said, I am a war risk underwriter, but there are two types of situation which I'm not taking upon myself, where the vessel gets into trouble under quarantine regulations owing to the characteristics of the vessel or the crew, and where the vessel gets into trouble with customs. Note that Mr. Mustill did not put it as the vessel gets into trouble with customs because of the acts of the crew. It's where the vessel gets into trouble with customs. And those submissions were obviously repeated in the Court of Appeal, because if one goes forward to tab 6 at page 495, we have Sir Gordon Wilmer with his marine expertise saying at the foot of the page, the last 3 lines, the common sense of the matter, as Mr. Mustill put it, is that by that clause the underwriters were in effect saying, we will not pay for loss caused by reason of the crew being sick or being caught smuggling. That is putting it in everyday language, and I would agree that that is prima facie what the exception means. Of course, he was dealing there with the crew being caught smuggling because he was expressly addressing a case of barratry. But the emphasis we submit appropriately is on smuggling. This same conclusion was expressed by Lord Justice Fenton Atkinson at 494C. He says, just below C, on the face of it, the special court appears to have been a legally constituted tribunal with jurisdiction to try cases of attempted smuggling. And for the purposes of this case, I can see no distinction between smuggling and infringement of customs regulations. That's what it's all about. It's about smuggling. So 2 elements. Firstly, the reference to customs regulations is aimed, at least primarily, at smuggling. And secondly, although in that case the misconduct of the crew amounting to barratry was covered, the role of the exclusion was to cut out from cover loss or loss of use of the vessel which was caused by their smuggling. So other forms of misconduct were covered, but misconduct in the form of smuggling was not. And we say the analogy here is perfect. What clause 1.5 covers is malicious acts which cause damage to or loss of the vessel, or loss of use of the vessel. Save that, it does not cover loss caused by smuggling. And if one was to substitute into the ANITA cover for third-party misconduct instead of crew misconduct and assume the guilt of the crew for smuggling could not have been proven, there's no reason to doubt that the decision in ANITA would have been the same. The third point on the ANITA is that the central issue in the case and the way in which the judgments on that central issue are expressed is entirely consistent with our construction of the exclusion, and that includes the put-up job referred to in the judgment of Lord Denning. Essentially, what the Court of Appeal held was that once the insurers had proved that smuggling had taken place and that an order for confiscation of the vessel by reference to that smuggling had been made by the Vietnamese courts, they had proved all they needed to prove. It was for the owners then to show that the real reason for confiscation was something other than smuggling. Now, Lord 492, letter E onwards is the first passage. That's in Lord Denning. Mr. Justice McCatterall found differently on the burden of proof. And if I can just highlight a few passages, although the passage begins at E, just below F, but in the course of the case, the underwriters adduced evidence to show that these transistor radio sets were smuggled on board, that the ship was confiscated for smuggling by order of the Vietnamese court. That evidence shifted the legal burden of proof on that issue to the ship owners. And at the foot of the page, the last 3 lines, it was for them, i.e. the owners, to show that the special court acted without jurisdiction and under political direction. So what he's addressing is the reason for the confiscation. Was it really a breach of customs regulations, or did they act without jurisdiction and under political direction for some other reason? And the next page, of course, if there were no goods smuggled and the seizure was a put-up job, it would be quite different. This is the entire edifice of the put-up job, which was then built upon by Mr. Justice Flo and has been built upon ever since by my learned friend. If there were no goods smuggled, it would be different because there'd be no infringement of customs regulations. It would also mean that the detainment or confiscation in this case wasn't by reason of a customs infringement, because firstly, there wasn't an infringement, and secondly, it wasn't the real reason why they were confiscating the vessel. There was some other ulterior purpose. He goes on to say, but once it was proved and admitted that it was a plain case of deliberate smuggling, such as would be condemned by any court in any civilized country, that the case was brought in regular manner before the courts of that country, I think the evidence was quite enough to discharge the burden on the underwriters and to put it on the ship owners. So that's the first stage. The second stage, again, if there were no laws in Vietnam which warranted the seizure and the court had acted knowingly outside its jurisdiction, it would be different. And then above letter C, the lawyers in Vietnam argued that it should be confined to the means of transport owned by the guilty smugglers, but the language of the text is wide enough to cover any means of transport belonging to private persons, and he addresses the legislation. So again, he's addressing whether, if the court knowingly acted outside its jurisdiction, there was some reason other than infringement of customs regulations for the confiscation. Of course, as I've accepted earlier, one can, in one sense, refer to that as a causation test, what caused the court's decision. But actually, in essence, it's asking for a reason for the confiscation. The third approach, letter E, yet again, if there were evidence of political interference with the course of justice, so that the court acted on the instructions of the politicians and not on its own judgment, it might be different. And a few lines down at F, he says, if there was direct intervention by politicians commanding the court to confiscate the vessel without any foundation for it, then of course the loss would not be covered, because the confiscation would not be by reason of customs regulations, but by reason of the political interference. He said the loss would not be covered. I think that wouldn't be covered by the exclusion. That would again be another reason for the confiscation. And when he sums it up, he says, looking at this case quite broadly, it seems to me to raise simply a point of causation. Was the confiscation due to a breach of customs regulations in Vietnam, or was it due to political intervention unconnected with the breach? On the facts of this case, it was a clear breach, and everything followed in direct sequence from it. But actually, when one looks at the questions that he's posed himself, although he describes it as a question of causation, and I'm not frightened of the word causation, I still say that I succeed even if it's causation, but actually, what he's really addressing is the real reason for the confiscation. But in any event, however one construes the language, even if one says causation, what they are asking about, and what this judgment of Lord Denning is asking itself, is about the link between the infringement and the confiscation by the authorities. That is the only relevant question, whether one expresses it as a reason question or a causation question. It's asking about that link. The link between the barratry and the infringement doesn't enter into the equation at all here. My lords, the same analysis applies to the judgment of Lord Justice Fenton Atkinson at 494A to D. He says, the result of this case depends, as I see it, on the answer to the question, was the decision of the special court to order confiscation a bona fide and independent exercise of its powers, or what it honestly believed to be its powers under the relevant decrees? The answer is yes, and in my view, the plaintiff's loss arose by reason of infringement of the customs regulations. If, on the other hand, the answer is no, the special court was not acting as a bona fide as an independent judicial body, merely acting as a puppet court following directions of government or knowingly exceeding its powers, then the loss arose by reason of a political or executive act. And note, we say correctly, the learned judge is using the words of the clause by reason of, and again is asking the question, why did they do it? On the face of it, the special court appears to have been a legally constituted tribunal with the jurisdiction to try cases of attempted smuggling. For the purposes of this case, I see no distinction between smuggling and infringement of customs regulations. And then just below letter E, he says, my view, the underwriters on whom the onus lay to bring the case, with the exception, showed a blatant case of smuggling, or perhaps more correctly, a strong prima facie case of an infringement of customs regulations, followed by a proper hearing by a lawfully constituted tribunal, to whom this court should be slow indeed to attribute bad faith. If there were nothing more, I would think it plain that the confiscation of the Anita fell within the exclusion. And then at the foot of the page, he addresses an argument about excessive jurisdiction, said to break the chain of causation, and he rejects that argument. But he goes on to say in the next page, between A and B, therefore, if the special court took the wrong view about it, which I doubt, there is no reason to suppose that they did so arbitrarily or without genuine belief in their duty to order confiscation. I agree with Mr. Justice McCatter and Lord Denning that a bona fide error in construction in this point would not break the chain of causation. Now, again, he's referring to the chain of causation, but why would not a bona fide error break this, what he describes as chain of causation? And the answer is, we submit, that because even if they made an error, the reason for confiscation remained the infringement of customs regulations. It remained the reason, even if it was an erroneous one. And so it doesn't detach the infringement from the confiscation. Or vice versa, I should say. It doesn't detach the confiscation from the infringement. And then finally, Sir Gordon Wilmer, somewhat more briefly, at page 496, at letter C, he says, the ordinary man, if asked what was the reason for the ship's confiscation, would surely reply that it was by reason of the members of the crew having been caught smuggling. In the same way, I apprehend that a burglar who is caught, tried, convicted, and sentenced to imprisonment would be regarded by the ordinary man as being imprisoned by reason of the offence of which he had been found guilty. I do not think that in the circumstances of this case, the interposition of the decision of the court between the alleged offence and the ultimate confiscation was such as to break the causation in the manner alleged. And for that reason, he upheld the application of the exclusion. My Lords, all of this we submit is entirely consistent with our construction of 4.1.5. The fourth point of significance about the Anita is that when the 1983 version of the clauses was being drafted, the Anita would have been a very important part of the context. If there was any cause for concern as to whether an insured peril should be trumped by this exclusion, or as to whether it should be applicable to smuggling regardless of who was responsible or could be proved to be responsible for it, the opportunity was there to qualify it. It would have fallen for consideration, particularly in the context of the expansion of cover for malicious acts to encompass not just physical loss or damage, but also a CTL. No such qualification was introduced, And we submit it's hardly surprising in circumstances where the language of the exclusion itself demonstrates that underwriters do not want to cover the consequences of smuggling. Now, my lords, those are the two most important authorities because they predate the clauses, but there is help also from the wondrous and Cleovoulos of Rhodes. And Lord, although those post-date the 1983 clauses, of course, firstly, they are the context in which this policy was entered into. Secondly, the results in those cases have, or what was said in those cases, has not caused any revision of the clauses or indeed any clamour to revise them. They have remained as they are. So they are significant to that extent. And also, one has to bear in mind that there is a need for certainty when one's dealing with these international clauses, and the court should not be eager to overturn decisions which have stood for some time and which appear to be acceptable to all concerned because no amendment to the clauses has been sought and no qualification to the clauses was sought to be imposed in this case. The wondrous first, my lords, in the Court of Appeal at tab 4. Pages 459 to 60, Lord Justice Lloyd. At the foot of the left-hand column, one of the submissions that was being made was that infringement must mean an actual infringement. And Lord Justice Lloyd says that's an oversimplification for the following reasons. And the first reason he gives is I cannot see why the parties should have intended to draw a distinction between quarantine regulations on the one hand and customs and trading regulations on the other. In the case of quarantine regulations, there does not need to be an actual infringement. It is sufficient that the detainment is under the regulation. Why should the parties have required something different in the case of customs and trading regulations? That supports our submission that one does glean assistance to the construction of the clause from the words under quarantine regulations. This is all part of a piece, and we adopt Lord Justice Lloyd's equating of the language used in these two provisions. Then there's his second reason, and he says it doesn't make commercial sense to draw a distinction between actual infringement and threatened infringement. That was a case where if the vessel did attempt to leave, it would infringe, and so it didn't. We say that is also only consistent with our construction of infringement, explaining why the detainment is occurring. If it's explanatory, then one can see why it doesn't matter whether it's actual or threatened. The third reason, my lords, at the foot of the right-hand column, is as to the interrelationship between clauses 4.1.5 and 4.1.6 and the covered risks, and I've read that passage earlier to my lords. We say that supports our construction that 4.1.5 is taking all customs issues and most importantly all smuggling outside the scope of cover, regardless of the reason for infringement, hence his language in the left-hand column at the end of the first paragraph, for whatever failure to obtain customs clearance for whatever reason. Lords, that's all I wanted to say about the wondrous as being supportive of our submissions. And the final case then is Cleovoulos of Rhodes, which is at tab 8. And that case is on all fours with this case, save for the fact that the drugs were discovered at the vessel's destination rather than in the port where the drugs were attached to the hull. The only immaterial difference is that in the Cleovoulos of Rhodes, the crew were actually all acquitted of complicity rather than being convicted as they were in this case, but that is immaterial because, like the Cleovoulos of Rhodes, the case between the owners and insurers has proceeded on the premise that the crew could not be proved to have been complicit. If my lords need the facts, at tab 8, page 510, very briefly in the left-hand column at the top of the page, the vessel sailed from Colombia to Greece, where she was detained on August 20th, 1998, following the discovery of cocaine in a sea chest below the waterline. So cocaine attached to the hull below the waterline, as in this case. Master and crew were charged with drugs offences, although they were acquitted, but not until January 2000. In the meantime, the vessel was detained long enough to be deemed a CTL. And just some more facts to the right-hand side in the column under paragraph 6. On August 19th, 1998, the vessel arrived in the port of Alvieri in Greece in order to discharge a cargo of coal, which had been loaded in Colombia, same type of cargo as well. On the next day, during an underwater inspection of the vessel required by the Port Authority, a large quantity, 188.9 kilograms, ours was 132, of cocaine was discovered in waterproof packaging behind a grill and a sea chest on the starboard side of the vessel, well below the waterline. The officers and crew were immediately charged with drugs offences and detained. My lords, the first point is that Lord Justice Clark, again former Admiralty judge, adopts and endorses the approach in the Anita of equating the reference to customs regulations with smuggling. And so remember that the entire premise of this is smuggling committed by third parties who, if they fall within the definition of malicious persons, would have been acting maliciously. So at page 516, paragraph 38, he says, in the context of the Institute clauses, which is already stated, are intended to govern the insurance of vessels on an international and not solely English or European basis, the natural meaning of the expression seems to me to be much wider. It seems to me naturally to have the wide meaning given to it in the Anita, to which I referred below. As Lord Denning put it, the word should be given a business-like interpretation. Like Lord Justice Fenton Atkinson, I too can see no distinction between smuggling and infringement of customs regulations. And he elaborates on that on the next page at 517, at paragraphs 45 to 47. He quotes from Arnold, which is giving the words a wide meaning. The citation is, exception relating to customs regulations construed in the Anita, it was held the word customs regulations to be given a wide meaning as referring to laws in force in the country concerning whatever their form, country concerned, whatever their form, which deal with smuggling or other offences in the realm of customs. It thus appears that in 1981, which was of course before the 1983 review of the Institute clauses, the editors regarded this court as having given the expression a settled meaning. And that, we submit, is important and it's right. These words had a settled meaning when they were repeated in the 1983 clauses, and the settled meaning was that they applied to smuggling. And that's a settled meaning which should not be upset. At 46, he then cites from another edition of Arnold, and then to the same effect. And at 47, he says, thus appears that the editors of Arnold have throughout understood the ANITA as construing the expression customs regulations to include laws dealing with smuggling. Moreover, Volume 3 makes it clear that in the editor's view, the same meaning should be given to Clause 4.1.5. These circumstances, I would, if necessary, hold that the clause had a settled meaning for the purposes of the principle stated above, even if, on analysis of the court's decision in ANITA as to the true construction of the clause, was not part of the ratio decidendi. That is because the question of what was intended by the draftsman of the clause, seems to me, other things being equal, he would be likely to use the same expression in the new version as in the old, only if he intended it to have the same meaning as he ascribed to it in, as was ascribed to it in the ANITA. And he goes on to say in 48, in the next page, however, it seems to me the true construction was part of the ratio decidendi in the ANITA. And he goes on to explain why, and perhaps I can short-circuit that by jumping ahead to paragraph 56 on page 519. In all these circumstances, this court's view of the true construction of 4.1 is that part of the ratio decidendi of the ANITA and is on any view settled law. It follows that the judge was, in my opinion, correct to construe 415 in accordance with that settled meaning. So that is the first important point to emerge from Clearvillus of Rhodes. It confirms, and we say correctly, that there was a settled meaning for the meaning of these words as at the introduction of these clauses. It was a settled meaning which the draftsman can be taken to have had in mind, and to introduce a qualification into the clause that it only applies to certain categories of smuggling is utterly inconsistent, we submit, with that settled meaning. It's the language in the exclusion remains unrestricted, and its target, therefore, we submit, remains unrestricted. The second point about the Clearvillus...
Can you help me? I noticed the references to the edition of Arnold there. Is there anything in Arnold about the loss or damage to property insured by persons acting maliciously, which was the subject of consideration in the Shell Petroleum case, because it was contained in, I think, some different clauses, the Institute strikes clauses?
I haven't checked.
You haven't checked? No. It might be interesting to see which we can
I think because of the concession that was made,
right.
Our inquiries hadn't, and my legal researches didn't stretch to that aspect. So,
but we haven't heard anything of the Institute strikes clauses apart from that. No. Although these are the Institute war and strikes clauses, so maybe at some point.
The Institute strikes clauses are, I think, only concerned with with economic loss in the classic sense, whereas the strikes part of the war clauses are referred to loss of the vessel as such.
I'm not sure that's right. In the Shell Petroleum, they seem to have been separate clauses. One set's called the Institute war clauses, one the Institute strikes clauses, and the Institute strikes clauses says this insurance causes loss of or damage to the property hereby insured. So it looks like a property insurance, but they've then got combined in the 59 ones, so which precede. Anyway, it's all.
I haven't looked at that.
It may be not merit.
The important point about the submission I'm making at the moment is that smuggling is smuggling.
Yeah.
And that's it. And who it's by, who committed it, who could be proved to be guilty of it, which may be very difficult, once there's smuggling, and this is the theme coming through from all the cases we've seen, once the underwriters have proved that the case that there's smuggling and that there is a court order which has detained or confiscated the vessel, that's all they need to prove. And the only way out for the owners is what, in fairness to them, they tried to do in this case, which was to prove that there was political interference. The real reason wasn't infringement. There was some ulterior motive on the part of the Venezuelan authorities on which they failed at trial.
Right.
My lord,
Where are we?
I've just, can I finish?
Haven't you finished your time?
No.
Well, no, I think I've got till 10:02.
Yeah, well, sorry?
I think we've agreed that I have till 10:02.
I see. Right.
Yeah.
Causation, causation, my lord. Yet again, in this case, the approach is entirely consistent with ours. My lord's paragraph 60. The appellants submit that if contrary to their submissions, this is page 519, the Greek Narcotics Agents, the Narcotics Act enacts customs regulations. There was no infringement of those customs regulations by the crew because they were acquitted. Appellants say that it follows that the detainment of the vessel as part of the proceedings against her officers and crew was not a detainment by reason of any infringement of customs regulations. Conversely, say the infringement of customs regulations by a person or persons unknown was not the reason for the detainment. So that was the argument, and the answer is given at 61, where he said, it starts the judge rejecting the submission. It was common ground that there was an infringement of the Greek Narcotics Act, arrival of the vessel in Greek waters with drugs on board, which constituted the infringement. And he then continues at 64, 65, 66 of the judgment. Can I just, because read a few passages. 64, the fourth line, the drugs were smuggled into the country on board the vessel, albeit by others. The infringement naturally led to the investigation and charging of the crew into the detention of the vessel. Proximate cause of the initial detention was indeed the unlawful importation of drugs into Greece. 65, fourth line, the loss arose from detainment by reason of infringement. Again, he parrots the word of the clause, even though the infringement was not the responsibility of the crew, even though if criminal proceedings against the crew had not been instituted and continued, the detention could not lawfully have continued for 6 months. Proximate cause of the detention remained the initial infringement. And so our submission again is what he's actually doing is explaining why the courts continued to detain the vessel because of the infringement of customs regulations. And thirdly, final point on this case, there's no suggestion, either in argument or in the judgment, that somehow the infringement was not a relevant infringement because it originated in a malicious act on the part of the drug smugglers. And so we say these cases undermine the owner's arguments. If it was so necessary or obvious that there was an implied limitation on clause 4.1.5, one would have expected that to have emerged in the Anita or Cleovulus of Rhodes. If it only made commercial common sense for the clause to be construed as being restricted, one would have expected that to have emerged. And if there was any dissatisfaction with the results in these cases, one would have expected that to emerge. And really, owner's arguments in this case necessarily involve one of two alternatives. Either the Cleovulus of Rhodes is wrong, because the owners in that case ought to have succeeded, or the case can be distinguished because the ship moved. Neither of those submissions.
You mean moved across the Atlantic?
Well, it moved at all. Because I think learned friend says once it moves,
Has
it's
he really
not the
said
mere manifestation, it's now transporting the drugs.
You really said that.
He was.
I don't think I recognised any proposition quite as stark as that.
But I think he has submitted that it's transportation. Once it's transported, it's no longer the mere manifestation of the attachment to the hull. Something more has happened.
I mean, I think he might have a question about the correctness of this decision, mightn't he? Isn't that the...
Well, Clearview of Rhodes cannot stand if he's right.
I see, yeah.
Can't stand if he's right.
But in the end, the court concluded it must have been third-party smuggling.
Yes.
Yeah.
And the entire case proceeds on that premise, that the crew were acquitted. But my point is, that decision has stood since, that analysis that the exclusion does apply has stood, and nobody in the industry has batted an eyelid at it. Nobody has demanded a change to the clauses, and nor did these owners, when seeking insurance, seek a qualification to make sure that the consequence in Clearview of Rhodes did not apply to them. My lords, in the few moments that remain to me, can I just make a few comments about what my learned friend said about any financial cause? If my lord looks closely at the Wondrous, you'll see, and can I just give the references at page 461, Lord Justice Lloyd rejects any suggestion of there being an implied limitation on the ambit of the words any financial cause, and rejects what Mr. Justice Hobhouse had said about that, and just accepted that the financial cause must necessarily affect the ship because otherwise it wouldn't be causatively relevant, and it's causation that he focuses on. Similarly, in the Eliza Glacial, although Mr. Justice Toulson ruminates about a limitation on the clause, he finds the answer again in causation. One can see that in the passage quoted in the Court of Appeal at page 430. This is paragraph 52. In the case in which Mr. Justice Toulson had already cited what Lord Justice Lloyd had said about the breadth of the words, and Lord Justice Potter himself, when
Sorry, which paragraph was it in the Eliza Glacial? 52.
52.
Yeah.
Lord, yeah, it's page 430. See, he goes, if I can just highlight the passages, about 10, 12 lines up, it is easy to say as a matter of instinct that the exclusion under 416 would not apply in those circumstances, but as a matter of construction, I ask the question why it would not. It seems to me that in any given case, the court has to ask itself, as a matter of fact, whether the real or effective or dominant cause of the seizure or detention is a financial cause or something else. So having said he thought there has to be a limitation, the answer that he finds is in causation. And if my lord goes forward to paragraphs 61 and 62, and then on to the reasonableness of security, it's all about causation. And what Lord Justice Potter was saying was, in circumstances where the demands of the authorities for the release of the vessel were unreasonable, it cannot be said that the original seizure of the vessel for breach of the fishing regulations had ceased to have its causative potency. So it's not a qualification on any financial cause at all. He's simply saying, well, if they made an unreasonable demand, which it was not unreasonable for the owners not to accept because they were demanding security for more than the vessel was worth, that does not create some new or additional cause of loss. The cause of loss remains the original seizure. And that's how they get round, and Mr. Justice Toulson gets round what Lord Justice Lloyd had said about the breadth of the words. They don't say the words, in fact, are subject to a limitation. What they say is, it's always a question of causation. Time doesn't permit me to read out the passages, but if my lords...
They're pretty closely allied, aren't they, in some circumstances? I mean, if you looked at a ransom demand which was totally unreasonable or came from a terrorist, all right, the failure to pay it in a sense is a cause, but it's just not the sort of cause which is embraced by this, is it? So it may be a matter of construction.
Well, no, my lord, I think what Lord Justice Toulson is saying is actually, because he grapples with it, he says there must be some implied limitation, but then the answer he finds is causation. He said, because if the demand is so outlandish,
yeah.
Although, yes, there is a financial cause, the dominant cause remains the original act, because this is something which you couldn't reasonably be expected to accept.
You can't ignore it. So whereas just ordinary financial weakness, well, that's obviously within it, and similarly failure to pay a legitimate sum needed for your trading gain. Because
then that's causatively relevant, but not paying something which is outlandish. What that means is that the original cause, it remains the dominant cause, because what's happened is that original cause is being used to hold you to ransom.
It is odd. It means you interpret black financial causes including blackmail, but then say blackmail isn't the real cause. But that's a bit odd, it seems to me. I don't think blackmail was within that sort of clause.
What they're saying, it is a financial cause, but you're asking, what's its causative relevance? And that's how you avoid implying into these internationally used clauses some implied limitation that someone somewhere else in the world trying to use these clauses would not be able to see on the face of the document. That's the danger of implied limitations. Lord, I think my time's up.
Thank you very much indeed. Yes, Mr. Blackwood. Thank you. Yes, Mr. Chair.
My Lords, I suspect the most useful way of replying, and the shortest, is to concentrate really on the authorities that have just been cited and trying to wrap my submissions up by dealing with those at the same time. I'll be as quick as I can. I want to make some points on Corrie Burr, the Anita, and the Clear-Villiers roads, and try and wrap up some of the other submissions along the way. My Lords, Corrie Burr involved the construction of the FCS warranty, and as a matter of construction, and we've given the references in our case, it was clear to all members of the House of Lords that the relevant exclusion covered seizures from whatever cause, including barratry or any other insured peril. That conclusion on the construction of the FCS warranty in that case does not in any shape or form determine the construction of the relevant exclusion in our case. What is more pertinent perhaps for these purposes is its treatment of causation, because in the Corrie Burr situation, the court had to consider whether the loss had been caused by barratry on the one hand or by seizure falling within the warranty on the other hand, and per Lord Blackburn, what should happen if they fell within both. My Lords, we accept, and I just make sure there's no ambiguity about this, I think it was a point my Lord Hodge made, but others have made as well, we accept, as I said right at the start of my submissions, that detainment is fundamental to our insured loss. I've never shrunk from that. As I said to your lordships first thing this morning, our loss depends upon the detainment. But that does not determine, either as a matter of construction or as a matter of causation, whether the relevant detainment was by reason of the infringement of customs regulations. And that is the question which arises both as a matter of construction, but also as a matter of causation on our exclusion, which did not apply for determination in Corrie and Burr, given the way in which the construction of that clause was determined. And my learned friend says, based on passages in Corrie and Burr, he says, well, there was a subsequent fortuity of detainment based upon the detection of the vessel whilst it was hovering, awaiting the contraband to be collected. My lord, that subsequent fortuity of detainment, which was relevant to the exercise of comparative purposes in Corrie and Burr, does not tell you whether or not in our case the relevant detainment here was, as a matter of common sense and as a matter of construction, by reason of the infringement, by reason of the malicious act, or by reason of both. It being effectively my learned friend's case that it was by reason of both when the infringement and the malicious act are one and the same thing. And it doesn't matter for these purposes whether my learned friend asks a how question or he asks a why question, because the subsequent fortuity in Corrie and Burr of detainment, and it was the subsequent fortuity for the purposes of the exclusion in that case, because that was the way the exclusion was construed as applying to all detainments, doesn't tell you in this case whether or not the relevant detainment was by reason of an infringement, by reason of a malicious act, or by reason of both, when the act and the infringement were one and the same thing, which is a submission that I made this morning. So Corrie and Burr does not, in my submission, give you the answer to this appeal. My lords, secondly, the ANITA, my lords, I accept that the ANITA emblazoned on the minds of everyone in the market that some types of smuggling were plainly within the scope of the exclusion clause. But it begs the question, in my respectful submission, of whether or not it's all types of smuggling, as my learned friends contend for, or whether it is the type of smuggling stated in black and white by, for example, Sir Gordon Wilmer, where he said in that passage we have seen twice or once, I told you what it was, and secondly, my learned friend took you to it. Sir Gordon Wilmer, Mr. Mustall QC, we will not pay for loss caused by reason of the crew being caught smuggling. Now, that was not just the context of the decision in the ANITA and the facts of the ANITA, but it's the message that comes out of the ANITA, which is then emblazoned for all to use in 1983, when the Institute clauses repeat the same formula. And there is nothing in my submission in the ANITA to tell your lordships as a matter of settled context, when one comes to the Institute clauses in 1983, that all types of smuggling, even if perpetrated by those engaged in a malicious or conceivably a terrorist or politically motivated plot, also falls within the smuggling which was the intended scope of that exclusion. And although my learned friend says to your lordship, well, the ANITA was wrongly decided on Mr. Schaff's case because barratry was an insured peril, my lord, we do not accept that that is a legitimate submission for the insurers to make. We have never said that, and I think it's a point that your lordship, Lord Mance, put to me when I was making my submission, barratry smuggling is the paradigm case of the intended purview of the exclusion in its original format. The purview of the exclusion was intended to cover smuggling by the owners, smuggling by the crew. The ANITA is smuggling by the crew, and we have never suggested somehow that the ANITA should be, or was wrongly decided, or was per incuriam or anything of that nature. My lords, so far as causation is concerned in the ANITA, the causation question was a different question to the one which we have to grapple with in our case. The causation question in the ANITA was there a break in the chain of causation between a valid detainment and the 6-month or 12-month loss or whatever it was by reason of intermediate political interference. That was the case we tried to run at trial and failed, but it doesn't answer either as a question of construction or causation whether or not where you have effectively the infringement being no more than the malicious act, whether the detainment is by reason of, as I said, the malicious act, the infringement, or both. My lords, the clear voulos, and I'm sorry, perforce I'm doing this quickly.
No,
but
I think you're entitled.
But I'm trying to
Yeah.
tick the bases, as it were. The clear voulos, we deal with this in our case at paragraphs 77 to 82. Again, my lords, the clear voulos endorses the decision of the ANITA that smuggling falls within the purview of the exclusion and indeed is an important part of the exclusion. I say that it's not the only part of the exclusion because, of course, in the Wondrous, which we looked at separately, the Wondrous had nothing to do with smuggling. It was a detainment for more than 12 months. It was a classic case where people hadn't paid their customs dues, their taxes on freight, their taxes on cargo, and the vessel was detained for a very long time as a result of an infringement which had nothing to do with smuggling whatsoever. But putting that to one side, we accept that smuggling falls within the scope of the exclusion. But again, the clear voulos does not determine and was not understood by the editors of Arnold as determining the question of whether the malicious acts cover was, as it were, trumped by the exclusion in circumstances where the malicious act and the infringement were one and the same thing. And the point simply wasn't argued. And that may go back to the point which I know occupies your lordships as to whether this really is malicious acts at all. And I understand that is lurking in the background, as it were. But on the basis of the common ground, at least, which, as it were, represents how both myself and my learned friend have as it were, prepared for this argument, the clear voulos does not decide this point. Arnold didn't think that it had decided this point. And in our submission, the clear voulos simply proceeds on what was common ground at the time. But to be clear about it, just so there is no ambiguity, and my Lord Nance, I think, has this point, it is our case, we develop it at paragraphs 77 to 82, that it makes no meaningful difference whether or not acts recklessly perpetrated on a vessel, indifferent to the risk of detection and detainment, are crystallised either at the load port, brackets, with or without moving, close brackets, or at the disport. Because the perpetrators, in that case it was Columbia, who fixed the vessel's hull with drugs in the clear voulos, did so recklessly indifferent to the possibilities that the vessel would be detained either at the load port or at the disport. The vessel was in the grip of a peril from those malicious acts, from the word go, and those consequences were visited in Greece rather than in Colombia. But it makes no difference. And in my respectful submission, therefore, if I was appearing for the owners of the clear voulos, or on facts equivalent to the owners of the clear voulos, I would be making broadly the same submissions that I am making to your lordship, although the facts would be less extreme. My lords, two final points, if I may, if your lordships will just allow me these. The example of Mr. Justice Tolson and the Elisa Glacial of the terrorism plot, the vessel is seized, there's a demand for money, the owners say no, the detainment continues. Now, whether one analyses this as a matter of implied limitation on financial cause, or one analyses it as a matter of causation, or in fact, my learned friend Mr. Edelman would say the real reason for the continued detainment, it doesn't matter so far as the instinctive, common sense spirit of the policy response to that sort of situation is concerned. The answer is that the real reason, the proximate cause for the continued detainment is the terrorist plot. And if that's right for that example, I maintain the submissions that I made to your lordships this morning, because why is it not equally right for a recklessly perpetrated assault on a vessel rather than an intentionally inflicted one? Leaving aside whether this is a malicious damage act at all, for present purposes, assuming it is, assuming it covers intentional and reckless consequences, then if one can say of that terrorist seizure, parce Mr. Justice Tolson as he was, that is not a detainment by reason of the infringement of customs regulations, or on his example, it's not a detainment caused by an absence of a financial demand. It's in fact a detainment by reason of or caused by the original terrorist seizure. The same is true in my respectful submission of the example we have here. And the final point I make is that if one imagines the example which my Lord Mance has been addressing with my own friend of the Salem, Shell and Gibbs, which was in fact a case, this was the sanction busting case, where owners and the crew were privy to the plot, and the cargo is discharged surreptitiously in South Africa, and then the ship is deliberately sunk, but with the privity of the owners, so barratry failed. Imagine that sort of example, but the plot is detected by the authorities before anything happens to cause loss or destruction of the vessel, but the vessel is nonetheless detained because the authorities discover the nefarious intention to trade cargoes of oil to South Africa. Now, in my respectful submission, the war risk cover is intended to respond to that sort of loss consequent upon terrorist, it's not terrorist, malicious acts, political motivated acts, whatever you call it. But my learned friends would say to your lordships, no, because in fact, there's no physical damage here. And they would say, well, trading a cargo of oil to South Africa at that time, definitely a breach of trading regulations, possibly a breach of customs regulations. There's been an actual infringement, might have been a threatened infringement. We're in the realm of customs, we're in the realms of trading regulations, and therefore, the interface or the intersection between the insured risks and the exclusions mean the exclusions win. And we say, with respect, going back to the submissions I made this morning, that the intention behind this cover is to give a meaning to the exclusion clause which may not appear literally on the face of the exclusion, but nonetheless has to accord to the object of this cover, which is to provide comprehensive terrorist and malicious damage and malicious acts cover. And you get to the answer that we urge upon your lordships, either because you imply a limitation into the words infringement to give effect to what the overarching purpose of this cover is, or you say, as a matter of common sense, by reason of an infringement of customs regulations does not mean a detainment which is in substance by reason of the malicious acts which amount to one and the same thing. And my lord, that is my original submission, which I urged on your lordships this morning. My lords, it's 4:10, and I suspect that's probably enough for a long day. But in my submission, notwithstanding whatever your lordships may feel, just looking at the language of that clause, I urge on your lordship just a business-like interpretation of what actually this policy is about. I hope that is not too brief, but I've tried to cover the bases, my lords.
It had to be, yes.
Lord, can we have 7 days to put further...
Well, I was going to say, how long do you need? I don't know, 7 days would be, of course, applicable.
I hope to do it in 7 days, and it's our suggestion.
Well, if you need any longer, let us know.
My lords, I did over lunch just go back to the transcript to check the concessions that were made. And we can obviously put this in writing for your lordship. It was a concession not merely that the test for malice or malicious acts was as per Mr. Justice Coleman's judgment, but that, to quote Mr. Rainey, it is therefore sufficient if a person unknown deliberately affixes drugs to the hull of the vessel, either knowing that the vessel will be detained or reckless as to whether or not the vessel would be detained. So that was the concession. Obviously, your lordships want to know if that was right, but I feel on behalf of my clients, I do formally at least need to reserve a position on costs, because I don't quite know how all that will play out. Because
I think you're entitled to put that in front of us, although probably it's not necessary at this stage. What we're interested in is the substance, but we fully appreciate that it creates some difficulties for counsel who've advised on a particular basis if the court insists on dealing with it on another basis. But this is a matter of pure law, and if
I understand that.
it's not suggested there's factual embarrassment, I think.
No, it's not suggested that. All I would say, and I want to, my instructing solicitor's not in court, but because she's ill, but that the whole of the appeal process, starting with the granting of permission to appeal by Mr. Justice Flo, and also the issues upon which we then sought permission to appeal from Mr. Justice Hamblin's judgment as a result, were predicated effectively on a concession as to the malicious acts. And I'm not for one moment seeking to suggest that your Lordship should not reopen this. There are potential issues of costs, my Lord.
If it became critical, these would all obviously be very relevant submissions. But I think in the first instance, what we're interested in is 7 days.
It is enough
time. Well, that's admirable. I mean, literally, we're concerned to have the right answer rather than a hurried answer. So if you need
or the wrong answer,
slightly more, you can ask. And I don't suppose there'll be any problem.
Can I just make it clear for the record that we'll make the submissions in order to assist the court rather than because we positively sought to withdraw the concession.
We've made your position clear. Well, the court is very grateful to counsel, in particular, I think, in enabling this case to finish in 1 day, which is always cost-saving and sensible if it can be possibly done. The court will reserve its judgment, which will be handed down in the usual way.
Thank you.